So the issue of a state's outright concealed carry ban was recently struck down, and it's once again up for review on the merits after the Supreme Court's recent denial of emergency review. So let's break down what is happening in this critical case and what is going on with these concealed carry bans. Now, before we jump into the video, I want to thank one of the main supporters of this channel, which is 1st Phorm. You all know that 1st Phorm is an amazing company. They believe in freedom, the Second Amendment. They support what we do here on the channel. They also have amazing supplements. So if you're just trying to get healthier, if you need protein powder, pre-workout, anything like that, 1st Phorm has you covered. But again, like I said, the really cool thing about them is their values align with what we believe here on the channel. So if you're interested, check them out using the link down below. And if you use my link and you order something $50 or more, you can get a free 4-pack of their energy drinks, which are amazing. Now, as I mentioned in the intro, in this video, we're going to be discussing how the issue of concealed carry bans in New York have once again been ruled unconstitutional, and now the Second Circuit is set to reconsider and review that issue. So you may recall that recently the Supreme Court issued an 8-1 decision in the Rahimi case, and then they remanded the New York concealed carry ban cases back down to the lower courts for new decisions in light of what they said in Rahimi. Now, the primary case that was kind of going on for a while was the Antonyuk case, which is a case I believe run by GOA. And that was recently also seeking Supreme Court emergency intervention, and it was dealing with a preliminary injunction. However, that was denied by the Supreme Court. And because of that Antonyuk case and it being sent back down to the district court for a final merits decision, one of the major cases that we have going on right now is no longer kind of the Antonyuk case. That is still important. It's still making its way through the process. But there's another case dealing with the New York concealed carry bans, and that's on a final merits, and it's still in the Second Circuit, set to be heard and argued in front of the Second Circuit by the end of this month. That's because while the Antonyuk case was seeking emergency Supreme Court review, the other case, Christian versus James, actually got a summary judgment at the lower court level, which has now been appealed to the Second Circuit. And currently, oral arguments have been set for June 25th in front of the Second Circuit. Now, that decision in Christian essentially struck down another major aspect of the New York law, which has the whole catch-all, carry ban provision where you need permission to carry at certain locations. You would have to get the express permission from the property owner, and that was struck down by the district court on a summary judgment motion. So again, a final merits decision. That decision was then appealed to the Second Circuit by the Attorney General Letitia James, and it's one of those primary cases that we're watching going forward because it's on the final merits. It was a decision striking down the catch-all property ban, and now it's at a higher court level in the Second Circuit. The Christian case can be the next major carry ban case that will make its way to the Supreme Court, who has kind of in the past denied all interlocutory cases dealing with carry bans, and potentially this case could be the next big one because it's on the final merits and it's coming out of the state of New York. Now, this issue of concealed carry in New York has kind of been a long battle and really should have ended after Bruen. However, after Bruen, things got even worse in some states like New York, who decided to pass these hyper-restrictive concealed carry bans through laws like the Concealed Carry Improvement Act, also known as the CCIA. The CCIA was passed just 8 days after the Bruen decision, and there you had the governor say that they were doing it in direct response and in defiance of what the Supreme Court said in Bruen. This law was challenged in multiple cases, and there were multiple preliminary injunctions that were granted against various aspects of the CCIA. Since then, multiple cases like the Antonyuk case and others have attempted to get Supreme Court intervention on an emergency basis dealing with preliminary injunctions. And, again, that's kind of in an intermediary and kind of middle ground area of these procedural posture of these cases. Again, dealing with interlocutory issues, but the Supreme Court has categorically denied review of those cases. Most recently, once again, in the Antonyuk case, they were seeking emergency Supreme Court review, but that was denied by the Supreme Court. But while all these other cases were seeking emergency review, this Christian case was sent for review at the district court level, who then considered cross motions for summary judgment. Now, essentially what that means in layman's terms is that each side wanted the district court there to rule, on one or more aspects of the case in their favor on the final merits at an early stage of the case. Instead of going to a full trial, they essentially said, we think we can win on this aspect of the case right here and now. And ultimately, the pro 2A side won the summary judgment motion, struck down that aspect of the catch-all carry ban where you could not carry lawfully at public property or private property unless you got express permission. Now, in that decision, the district court judge, Judge Sinatra, stated that a newly enacted New York law makes it a felony for a concealed carry license holder to possess a firearm on all private property unless the relevant property holders actually permit such possession with a sign or by express consent. At least as to the private property open to public, New York's restriction is unconstitutional, a result dictated by the teachings of the Supreme Court's recent cases addressing individual Americans' right to keep and bear arms. Regulation in this area is permissible only if the government demonstrates that the new enactment is consistent with the nation's historical tradition of sufficiently analogous regulations. New York fails that test here. Indeed, property owners have the right to exclude, but the state may not unilaterally exercise that right and thereby interfere with the long-established Second Amendment rights of law-abiding citizens who seek to carry for self-defense on private property open to the public. That decision by Judge Sinatra relied heavily on what the Second Circuit had already said in other cases like Antonyuk and this one as well. When they were reviewing the preliminary injunctions, they also found at the preliminary injunction stage that the catch-all property bans were impermissible. And so here on the final merits, the district court is simply saying the Second Circuit already addressed this on the preliminary injunction stage. I already reviewed this at the preliminary injunction stage, and on the final merits, we still think this is unconstitutional. The court stated that as the Second Circuit observed in Antonyuk, no matter how expansively we analogize, we do not see how a tradition of prohibiting illegal hunting on private lands supports prohibiting the lawful carriage of firearms for self-defense on private property open to the public. So the state's justifications for these carry bans have been rejected once again, and the carry ban has been struck down once again, but on the final merits. Now, important once again for this case is that the Attorney General, Letitia James, has appealed to the Second Circuit, and she wants a reversal of that district court decision. That appeal has now been set for oral arguments. It's going to happen in front of the Second Circuit on June 25th. This is significant because the Second Circuit has already rejected this catch-all property ban multiple times in multiple cases, but before they were dealing with preliminary injunction reviews, and those were all at the preliminary injunction stage. There is a high likelihood that they will again find that that is unconstitutional on the final merits. That means that New York will have to either ask the en banc panel in the Second Circuit to review this issue or go to the Supreme Court on the final merits and ask them to review a concealed carry ban that they put in place in direct response to Bruin. That tees up the perfect carry ban challenge that the Supreme Court may have been waiting for a long time, since they keep kicking all the interlocutory preliminary injunction cases like Antonyuk. The only wrinkle with this whole concealed carry ban issue and the whole public property ban challenge that's going on right now is the fact that Hawaii, in their Wolford case, is currently also seeking Supreme Court emergency review at the preliminary injunction stage. Again, the case is dealing with a preliminary injunction decision. It's not the final merits like what's going on in this Christian case. And the Supreme Court to this point has categorically denied all of those interlocutory cases. However, I will note that Hawaii has a potential chance to potentially maybe get this reviewed by the Supreme Court, because you've recently had AG Bondi in the DOJ in the Trump administration file a brief in support of the challenge, and they asked for the Supreme Court to not only grant review to this case at this early stage, but also strike down what is going on at the lower courts with the defiance and strike down all of these laws that were passed in direct response to Bruin. But regardless of that, I think the Christian case is still very important. It's kind of one of the more important cases that we have going on right now with carry bans, because it's on the final merits and it's set to be heard and argued in front of the Second Circuit at the end of this month. Again, the likelihood is that the Second Circuit will rule the same way that they did at the injunction stage. And again, I believe that they're going to find that this ban and the catch-all property restrictions are in fact unconstitutional, because they've already said that in multiple cases. That again would prime this case to be the perfect challenge to eventually go to the Supreme Court on the final merits and to finally address these catch-all carry bans. So this is a case we're going to be watching closely, and I'm interested to see, what happens at the oral arguments. It's going to be interesting to hear those arguments. And again, those are happening on June 25th. So that's what's going on with the whole New York concealed carry ban issue and the carry ban issues at large. The Christian case, again, final merits in the Second Circuit, set to be heard and argued at the end of this month. It's one of the cases that's further along in the process than some of these other ones that are still dealing with preliminary injunctions and still trying to get the Supreme Court to step in at an early stage. But the Supreme Court has said, pretty much at this point, they have not been interested in any of those cases, and they kicked all of those. I think regardless, ultimately, this Christian case will end up in the Supreme Court, and the question just really is there another case that's going to make it there before them, or is the Supreme Court going to finally jump in at an early stage in a case like Wolford? So as we get more information, as it develops more, I will let you guys know. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And don't forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.